Hi, Zach. How are you? It says we're live. We'll give it a few seconds just to make sure, but it's usually pretty good about that. How are you, Zach?
I'm good. Good afternoon to you, and good morning from the wet, sticky state of Oklahoma on this early fall day.
Thanks for joining me on such short notice. Everyone, Zach and I have chatted on the phone a little bit prior to this, and Zach is an attorney. Zach, introduce yourself a little bit to the peoples.
Sure. My name's Zac Morgan. I'm an attorney. I'm originally from Oklahoma. I'm admitted in Oklahoma and Colorado state courts, as well as a variety of federal courts around the country. I've practiced law both in a criminal and a civil context. Most of my practice has been in the civil world, but even as a young lawyer, had the opportunity to train under some great lawyers and tried a lot of jury trials.
Uh-oh, Zach, I just lost your audio. There you are.
All right. Well, all right. So I've tried several jury trials, both in a civil and a criminal context, and most recently have moved into full-time academia. I'm on the faculty of a small university, which is my full-time job, but have been following even sort of dating back to Leah Remini and Mike Rinder on the Scientology the Aftermath series. I'd sort of always been aware of Scientology. It's not obviously real present in my part of the country, but I've always sort of known that it's been there, and then sort of started following the Leah Remini thing, and then found your page several months ago, and here we are.
Very interesting. Do you recall seeing the series finale of the Aftermath show that had several of I think two of Danny Masterson's victims on the program? Did you see that?
Bits and pieces. I haven't watched it in its entirety, but my wife and I used to watch it together, and then I was working out of town for a while, so we stopped doing that. But I've seen bits and pieces. I probably need to go back and watch the whole thing from beginning to end again. But
okay, I was just curious. So the main thing I wanted to get a lawyer's take on, we've been hearing from the testimony of Jane Doe 1, 2, and 3, just how involved Scientology's Sea Org members were, about 3 of them in particular that I can think of off the top of my head, how these Sea Org members were intimately involved in interrogating Danny and all of the victims.
Sure.
Were intimately involved in even ironing out a secret settlement agreement between Danny and Jane Doe 1. I, for the life of me, as a layman, cannot understand why none of these Scientology Sea Org members are on the witness list and are not going to be called to testify. And I want to get your take on why that might be, because it's easy for me to assume that it's because they're not going to cooperate. And
Sure.
From a layman, I go, throw them up on the stand and make them plead the fifth to every question. But can they even plead the fifth if they're not the one being charged? Help me understand what's going on here.
Sure. So it's sort of a multifaceted thing, and it's some of it's fairly simple, some of it's a little more nuanced, and we'll walk through that. So first and foremost, any person, when called to testify or when being interrogated by law enforcement, has the right to assert their Fifth Amendment privilege. That is an absolute privilege. There's certain privileges that are qualified, like qualified immunity for law enforcement and things. The Fifth Amendment privilege is an absolute privilege. Once you invoke it, you're done. And the threshold for that is fairly low. If the answer to the question, if truthful, may tend to either directly incriminate you or lead to evidence, the discovery of evidence that may incriminate you, you do not have to make that admission. Ultimately, a judge is the gatekeeper in that, but most judges, as they should, hold that as a pretty absolute privilege. And most judges take the position, it's not for me to determine whether or not this will incriminate you. Ultimately, that would be left to a charging authority, such as a district attorney or a United States attorney, or even a grand jury in states that do a grand jury charging process. There's also this issue that's a little more nuanced, and in the Church of Scientology, I haven't found any case law that definitively defines this, but every state and the federal rules of evidence recognize the pastor parishioner privilege. And in the conventional setting like the Catholic Church, if I, as a Catholic, go in and make confession to my priest, and I tell the priest all these horrible things I've done, the priest can't lawfully be compelled to testify about that, right? The priest cannot waive the privilege. I, as the parishioner, can. If I go in and say, hey, I told the priest all these bad things, I can rat on myself, but the priest can't rat on me. And with Scientology being so decentralized outside of sort of David Miscavige, at the local level, it seems to be very decentralized. I can guarantee you that was done strategically with the advice of counsel way back when LRH was doing his thing in the 60s and 70s. That was very much done probably on the advice of counsel. And because it's so decentralized, it makes it very difficult to determine, are these auditors that are receiving this information, or these investigators, whatever their role in the organization is that considered a clerical or pastoral role? And if I call everybody that's ever talked to Danny Masterson, the defense would be filing piles of motions to exclude their testimony on the grounds that the statements he made to them is protected by the pastor-parishioner privilege. And I don't know that any judge wants to have to sort through that to be the first judge to do that. Some court someday will do it, but nobody's done it yet.
So this is really interesting, considering how many years the prosecutor's office has had to itself understand all the nuances of the Scientology world here. Let me share some information with you, and you, as a jurist, how you would digest this.
Sure.
Within the world of Scientology, there is a distinction drawn between the priest-penitent nature of an auditing session versus an ethics interview. Okay. An auditor is, in the eyes of the law, a pastoral counselor. An auditor has to complete auditor training courses. There's even a little minister's course that an auditor usually does just so that they can actually call themselves a minister. Being an ethics officer does not require auditor training, and an ethics officer is not considered a minister. Even if you're in an auditing session with an actual auditor, within the world of Scientology, there is a distinction drawn between a confessional auditing session and a security check session, where the auditor starts the session by saying, I am not auditing you. That is how you begin a sec check. Because anything you say in an auditing session is, by the rules of Scientology, not actionable. You can't get sent to ethics for it. You can't get in trouble for it. But if it comes up outside of an auditing session, meaning in a sec check or in an ethics interview, it is actionable. You can get in trouble for it. I'm going to guess that this is the distinction that is made within the world of Scientology, that the law does not make this distinction. The law doesn't know the damn difference between a confessional, a sec check, an ethics interview, an ethics officer, an auditor. Would it be your position that that is probably the case? The law doesn't know the difference, and it doesn't care.
I think that's essentially it. I also think the other issue is, if the prosecution wanted to, and I'm sure they would love to have these admissions, these records admitted, there would, before the trial, have to be days-long evidentiary hearings for the judge to make a legal finding as to a legal determination as to the role of this individual in this capacity, right? It's not, if I go have lunch with my pastor, that's not a protected conversation. But if I shut the door and say, hey, boss, I want to talk to you, that's a completely different setting, right? The other thing is, because of the rulings as it pertains to Scientology, Judge Almeida has made in this case, in order to get those, let's say they could establish that some of this was not confidential privileged communication between Danny Masterson and somebody in the C organization or at any level of Scientology, assuming they could make that finding, in order for those records to be admissible under the rules of evidence, there would have to be testimony from somebody like you. But the problem is, you removed from the organization now. So there would have to be somebody internal to the organization, or somebody qualified as an expert witness, which is a whole process in and of itself, to lay the groundwork to establish these roles, why they matter. And then they're the person that can then establish the methodology. Then you would call the individual Scientologists for their testimony, which sort of leads to a different point that I'll make in a minute.
Interesting. So I guess my thought was, considering the prosecution has had 5 years to bring this case to trial, I would have thought they would have just jumped through those hoops, because the truth is that's not difficult. Like the things that I'm talking about, these are things baked into the very core of Scientology policy and tech itself. These are not like something that's going to change over time.
Sure.
And they could have gone through the trouble of getting someone certified as an expert witness. They could have, because we have these victims up here saying, I spoke to this person at Scientology about, and by the way, these people are not auditors. They talk about Chris Scoggins or Angelo Scoggins and his wife. The one was the ethics officer, one was the chaplain. This is a chaplain in an administrative sense, not in a religious sense.
Sure.
These are people who are actively involved in conversations that are being testified to, and yet the prosecution doesn't want to call those people to testify. They couldn't jump through these hoops to get this sorted out as what's admissible, what's not. It just maybe it's just not necessary. Maybe that's what it comes down to. But
right, and that sort of leads to the second point, which is sort of two-prong. Attorneys love points and prongs. I don't know. We love points and prongs. It's a thing. The second one is this. So part of it, take a step back. Part of it is, they may very well could have established all this, but I think with Judge Almeido's rulings limiting the amount and the type of testimony about Scientology that can come in, I think they're running into maybe a buttress there, a legal restriction because of this pretrial ruling. But then the second thing is, I can call any witness that I want to, and I guarantee you somebody in the prosecutor's office, even if not an attorney, an investigator, has probably tried to or has spoken to most of these people. And I could subpoena all of them. A subpoena is a court order to show. If you don't, you go to jail. It's very simple. But if I have, most of them would probably be hostile. We've already had one go hostile. And at some point, one or two hostile witnesses, the jury looks and goes, why are you so angry with this attorney who's just asking you questions? You get enough of those, the jury starts to wonder, who's the problem here? There's only one common denominator, is the person in the well asking questions. Right. So then do we really want to call this many angry, irate, pissed off people, right? Who we're going to have to force feed information to, like pulling teeth. The other issue is there are rules of evidence that say, if I have 15 people that are going to say the exact same thing, I cannot call them all. I can call 3 or 4, but at some point the evidence becomes repetitive and cumulative, and it doesn't really help the jury. You've clearly established the point. 8 more people doesn't get us any closer. It just makes this last 2 weeks longer.
Right. And actually, now that you mention that, it is interesting to note that the defense has not once objected when the victim has been testifying about a conversation they had with somebody at the Celebrity Center. That the defense hasn't even been trying to say like, this is hearsay, or that didn't happen, or whatever.
Yeah, and hearsay, I love when people want to talk about hearsay, because I have all the respect in the world for the judges who dedicate their lives to sitting on the bench and enforcing the rule of law. It's not something that I could do. Most of them are incredibly intelligent people, but there are a lot of judges and trial lawyers alike who struggle with hearsay. It has a legal definition. Then there are 72 specific exceptions to the rule, and 22 things that are expressly not hearsay by statute, although they would otherwise be, except it says these things are not hearsay. So hearsay is, in law school, we spend months talking and discussing and studying just hearsay. In all the rules of evidence that govern trials in America, we will spend half of a course studying just hearsay and its exceptions.
Wow. Well, I think the Johnny Depp Amber Heard trial highlighted just how much even jurists don't understand hearsay, much less lay people.
Absolutely. And I thought in the Depp Heard trial, I felt like the judge did a fantastic job of managing her courtroom and progressing that trial in a timely manner. And I thought she was very fair in her application. And there were times that she missed the hearsay rule, but she consistently applied her understanding of it. There were times that she omitted and struck certain questions and certain evidence for both sides that I thought, it's not really hearsay. But the thing is, it's how we present it. If I present something for one purpose, it's hearsay. But if I present that same thing for a different purpose, it's not hearsay. It's all in how the lawyers are able to craft the argument to get it admitted.
Interesting. Help me understand. There's some dynamic in play when Cohen, the defense attorney, is asking the victim, the witness, would it jog your memory if I showed you the transcript? And there seems to be some strategic value to saying, I'm not sure that it would, or no, I don't think that it would. What is going on there?
So there's a technique. If a person testifies differently at trial than they testified prior under being previously sworn, traditionally we see it in a deposition. That prior testimony is itself, the transcript itself is not admissible. The transcript itself is actually hearsay because it is an out-of-court statement offered to prove the truth of the matter asserted. But what I can say is, if I ask you yesterday under oath, Aaron, what color is the sky? And you say it's blue. And I ask you today, Aaron, what color is the sky? Under oath in front of the jury, and you say it's yellow. I'm going to say, but that's not your answer yesterday, was it? And you're going to tell me, I don't remember. Well, if I hand you a copy of your transcript, do you think it would help you remember? I don't care if your answer is yes or no. I'm going to hand it to you anyway. And I'm going to say, I want you to read that. When you're finished, look up at me. Does that help you? If you still say no, I'm going to say, I'm going to read it along and I want you to follow along with me. I'm going to read question, answer, question, answer. Aaron, did I read that correctly? Yes, you did. Cool. I don't need your admission now. I can move on. I got your testimony in anyway.
What if you say, did I read that correctly? And I say, I don't know.
In that case, I would ask for a sidebar with the judge, and I would ask for the judge to order the witness to answer the question, because the witness, I don't know, is not a truthful statement. I either did read it correct. That's an absolute. I either did read it correctly or I did not. If you are a literate person, you can make that determination, and the judge can order, answer that question yes or no. Failure to do so is contempt, and you can be placed in jail.
I see, because you're not asking them, is what I read the same thing you recall saying yesterday? You're just saying, did I correctly read the line off of this page?
Yeah. Did I read from the first letter to the period correctly? Yes or no? I'm not asking you, is it true? I'm not asking you, did you say it? Did I read the document correctly?
I see. So, okay. So why is it that the defense attorney even has to say, would it jog your memory if I show this to you? Are they just trying to do it as easily as possible in the first place?
They have to establish that the witness has what's called lack of recall. I don't remember, I don't recall. If the witness says, I don't remember, I don't recall, I then have to establish, by giving you this document, it's going to help you remember. Will it not? Yes, it will. Now that you've admitted it's helpful, I can ask the judge, Judge, may I approach the witness and hand him a copy of this transcript, please?
I see.
But I cannot unilaterally just hand a witness something. They have to acknowledge that this particular thing is helpful. We see this same theory in a roundabout way when we call in, for example, the investigator in a murder scene and say, do you know what kind of gun it was? Yeah, it was a black 9mm. I'm going to show you this. What is this? This is a black. Is this the gun you found there? Yes. Now we've established this is the thing that we're claiming it is.
Interesting. Have you been following along with the updates in the testimony?
Yeah, I've followed Tony Ortega and his blog, and of course your channel, and the Long Crime Network's carrying quite a bit of coverage on it right now as well. But most of their stuff's coming from Tony.
Do you think that the defense has been effective at all in bringing the credibility of the witness's memories into question?
To the extent that they can. Sometimes the defense strategy, TV's great for these home run plays, right? Oh, look what I found under the counsel table after you went to lunch, that kind of thing. The reality of it is a defense attorney's job is to poke enough holes that the boat slowly sinks. We're not going to hit it with a torpedo, right? Cross-examination, if done effectively, is death by 1,000 cuts. And one of the things that the best trial lawyers in the world struggle with, we all struggle with it, even those, the Johnny Cochrans and the F. Lee Baileys of the world, we all struggle with it. The best cross-examination is one I don't have to conduct. If I feel like the prosecution didn't get out the information from that witness to prove something, if asked cross-examination, my answer is going to be no. Because if I get up there and cross-examine them on something that opens a door on redirect, now I've got to come up with another strategy on the fly to defend that redirect. The best cross-examination sometimes is no cross-examination. Because if I feel like my opponent, and it's the same even if I'm the prosecutor when the defense puts their case in chief on, if I don't feel like my opponent did a good job, I'm not going to do them a favor by asking questions. I'm going to get out of the way.
Interesting. So in the opening statements for this case, it seemed the defense created the impression that they had a lot of ammunition when it came to various omissions and inconsistencies and inaccuracies in the different reports that, or even the different conversations that victims had with different officers at different times. And every witness, I mean, we've heard from all three victims so far, and there's already been, you know, cross and recross of all three of them. I haven't seen any inconsistencies brought up that didn't seem to be the result of actual errors in the police reports themselves, or victims pointing out, like, if I didn't say this entire story to Officer A, it's because I was just answering Officer A's questions and they didn't tell me that. Right. I just as a layperson, every inconsistency seems to go back to some deficiency in how the officers have conducted their own reporting. Is that usual?
Generally, the reality of it is, especially in a city like Los Angeles, the number of reports that are going to mirror these, even outside the Church of Scientology, they have an entire wing of their detective unit dedicated to sex crimes and crimes of this nature, right? They're very good, but they are very tired. And most of the time, there's a template set of questions, and really their job is to generate enough evidence to give to the DA to investigate. That's really their job, right? Lawyers are trained in how to put people in boxes and shape questions that you can't get out of and that sort of thing. That's our job. Law enforcement's job is to find bad people, get them off the street, and let the DA try and find a way to put them away for a while. Like, that's right. The roles are different. Additionally, if I'm given a bag of dog crap as a case, I'm going to polish that turd every which way I can. And even if I have a little inconsistency, my job as a lawyer is to argue it and spin it and fluff it up and spray paint it and put hair and makeup on it and say, look how big an issue this is. The prosecution's job is to say, you know what, those statements were small inconsistencies, but if we put that in the giant framework of this puzzle that is a jury trial, it's very, very small. Because again, if I'm stuck with a bag of stinky dog excrement, it is what it is, right? Because if I'm the defense attorney, my argument is, you know what? There was an inconsistency about something that didn't matter. If there's an inconsistency about something that doesn't matter, is it possible that there's an inconsistency about something that does matter? And that's reasonable doubt.
Sure. So I can understand that. It also seems that it would be easy to get a jury to understand what you just explained, which is it's the police officer's job just to put enough information together to turn it over to the person who's going to investigate.
Right.
And that if you have to fall back, if your defense strategy is to fall back on inconsistencies in reports that by their very nature aren't even designed to be complete in the first place, then you are dealing with a bag of dog shit.
Yeah. And you know, the best lawyer in the world can get a case with terrible facts and they look like a terrible lawyer. They may be the most gifted trial attorney to ever grace the face of the earth. But if F. Lee Bailey can't turn, you know, a turd into a turnip, like you can't. I mean, we can get creative with our arguments. We can ask questions a certain way. We can lay this foundation, and then we can lawyer our butt off. But I'm still stuck. At the end of the day, what I'm trying to lawyer is a trash bag, right? I mean,
yeah. Is that how you see this case, essentially?
You know, and essentially, and you and I spoke about this when we spoke on the phone a few days ago. But to the defense's credit, and you know, as a neutral party in this, I want every person, and you and I talked about this. Every person has the right to the best defense representation that they can get. Whether you're dirt poor or you're the wealthiest person on the planet, everybody is guaranteed that right. And I believe as an attorney, I believe everybody should exercise that right. To the defense's credit, as from what I can ascertain, they haven't gone down the victim blaming route as much as they could have. That is
yesterday. It got close. Got close yesterday.
Traditionally, that is one of the go-to defense mechanisms in these types of assault cases, right? It's sort of like the old Bill Clinton. Depends on what the definition of is. What is the definition of no? Is right. So it's sort of these moving parts. Can a person consent if they're compromised due to intoxication, right? And the law's sort of squishy on this, but also clear. It's pretty nuanced. But to the defense's credit, I think they've done what they could with what they had, without victim blaming, because especially in a town like Los Angeles, that's going to turn a lot of people off rapidly.
The victim blaming?
The victim blaming will turn a jury off in a hurry.
And do you mean more because Los Angeles is, kind of the woke culture? Is that what you're talking about?
Yeah, it's very much a liberal city. It always has been. It's also a city that sort of spearheaded the start of the cancel culture, if you will, right? In more, and we also tend to see less conservative evangelists in that community. In a community that has a high population of conservative evangelical type Christians, they tend to get on board, good or bad, the victim blaming a little bit because of the way that they try to raise their families. And I'm sure there's probably one or two on the jury, but that doesn't tend to be near as pervasive in the Southern California communities as it does, say, where I live, right in the middle of the Bible Belt.
Right. After some swap outs of the jurors, the jury is now 6 men and 6 women. God, I just cannot imagine being a woman on that jury and being like, "Yep, seems like reasonable doubt to me."
Yeah, right.
It's really something.
And there's an art. People will disagree. This is one of the biggest areas of contention among lawyers. Some people will spend millions of dollars on jury selection consultants and jury selection experts, and some people say, you know what, pick 12 out of a hat. I'm going to try my case. I win, I lose, I lose. I'm somewhere in the middle. There is some psychology behind it. I know, depending on my facts, does a blue collar farmer and rancher, is he going to be more sympathetic to my case, or do I need a highly educated, sophisticated person like a banker or a lawyer or a doctor? Is a stay-at-home mom or a school teacher? We know some of the psychology behind that, but the psychology in cases like this of jurors, it tends to be pretty clear, both across the gender spectrum as well as across the education and occupational spectrum. So we'll see.
Interesting. If things get really desperate here, and they're coming down to the wire, and the defense just has scored no points, I mean, to me, would you expect Danny to testify on his own behalf, or is that just? Would you ever expect to see that in this case?
No. No matter how powerful what he has to say is, he's open to cross-examination, and the LA County District Attorney has put her top legal team on this case.
So Cohen would probably step down before allowing Masterson to testify. Because in the beginning of this trial, I mean, I remember the judge specifically addressed Danny and said, no matter what your attorneys are telling you, you have the right to testify if you would like. And I thought, wow, that's a little out of turn, in my opinion. But is that
no, that's standard. That's an admonition that no matter the legal advice your attorneys give you, it's ultimately your decision. I can lead a horse to water. I can't make it drink. I can drown it trying, but I can't make it drink, right? No matter how much I tell you, you are not going to benefit yourself in any way. If you get in that box, sit on your hands, I will tape you to that chair if I have to. It is your right to stand up, raise your right hand, sit in the box, and then tell the truth. With these highly skilled trial lawyers, as a prosecutor, if I see a defendant stand up out of his chair, I mean, it's almost like a drag racer revving its engine at the starting line. This is what I've spent my life. I'm getting ready to put your head on a tee, and we're going to go play t-ball for the next 6 days. And that's what makes criminal trials different than civil trials, right? If Amber Heard had been prosecuted criminally in some capacity related to the Johnny Depp situation, no way she takes the stand. In a civil trial, she doesn't have a choice. She was served a subpoena to testify. And you saw the wheels came off the bus, right? We all saw the cross-examination. Miss Heard, you didn't give that money to charity, did you? I pledged it. No, I didn't ask what you did. I asked what you didn't do. You could have pledged it to the moon. Did you ever write a check and put that check in the hand of somebody that cleared the bank? No. I'm done. I'm sitting down.
Right. Fascinating stuff. All right. Well, I believe you have a 1 p.m. hard stop here. So,
I do.
Thank you so much for doing this with me, and
Of course.
and let's do it again. We'll have plenty of opportunity here, I think.
Sounds good, Aaron, and I hope you get that 100,000 hits. Looks like you're getting close.
Thank you so much. All right. Have a great day, everyone.
All right. We'll see you soon.